how did that come about? Like, how did you become so interested in the investor's point of view?
So let me start by saying that I'm an attorney, but when I was also an attorney, I started being a realtor. And this was not, it was kind of combined so I could understand what the realtor side is as well. So when I started talking to realtors, I, of course, met a lot of investors. So investors were kind of like the backbone of us trying to figure out what to do with some of these properties. A lot of probate cases. I have right now a 21-year-old that is living in the home alone, does not want to do probate. So then we brought on an investor. We assigned the inheritance to the 21-year-old. So it kind of helps. So that's how we know investors, is because it kind of helps us proceed faster. The 21-year-old does not want to go through probate. They don't want to go in front of the judge. They're scared of everything. So I said, why don't you just hand this to an investor and let them take over?
So that's interesting. I know I've got a deal like that going with you right now. And it seemed very attractive to me, at least. Why don't you help for all of us that don't really know the exact process, and that would be me too. I mean, I understand it kind of vaguely, but the timelines, the processes, like my mom passes, she has a will. What happens next?
So what a lot of people don't understand is that when you have a will, they assume, okay, you're already done. You could bypass the whole probate. It's going to be easy. I just transfer the name into my house. Unfortunately, no, and they don't realize that until they go talk to a realtor. They tell them, no, this house is not in your name. So when you go into probate court, you actually have to put the original will into probate. Now, probate is a timely process. One of the major points of why this is a long process is once there is an administrator appointed, that takes 6 weeks. You have to wait 4 months for all the creditors to submit their claim if they have any. So it's usually our job. Now, of course, I'm sorry if I'm talking too low. I'm also a bankruptcy attorney, so I know when sometimes there's claims, and I have decedents' heirs telling me, can you pull credit? Can we see what's there? So if there's any credit, anything that needs to be paid. So those 4 months are there, and then we file the final accounting. That's about 2 months out when that hearing is. Then, of course, the judges are slow. They sign orders about 3-4 weeks later. So you're looking at a process that takes sometimes generally 9 months to a year. It's a long process. And a lot of people, they don't want to go through that. They want their money now. They don't care if they get 50%. They just want it faster, which is understandable. They're living off nothing.
So in that 9-month period, I mean, I just was at a house I'm in the middle of trying to get, or that I purchased an assignment from the heir, and the weeds are tall. The house is, I wouldn't say going to heck, but I mean, there's nothing being done to the property. And technically, I don't have ownership, or I don't have a position in the property other than a contract that that Mona and I put together for me to buy the rights to the property. But
not necessarily. They will not get involved as long as the will. That's why it's always good to have a will to kind of outline who the beneficiaries are. If they have any otherwise inkling that there is somebody else out there, then you're not the only beneficiary. There's a lost adopted son out there that we forgot about. And again, adopted, there's a whole bunch of rules, but it could. But usually, no, the judges are okay with the joint venture and actually assigning the rights. Assignments happen all the time because a lot of these, mostly it is people who do not have income. They were depending on their parents to actually, support them. And then all of a sudden the parents are no longer there. So then they don't have income themselves to continue having a house, paying all the bills. So for them, waiting even about 7 to 8 weeks to be the administrator to sell the home, have a house escrow for a month, it's just not feasible for them. So to them, they would take the 75%, 50%, and actually just transfer the assignment. Yeah. So usually the judges have not said no, but toward the end of it, there is a very specific law of what the assignments have to say. You can't say on there certain things, so then that's when the judge could come back and say, no, you can't say those things. But I've done assignments, so I know my assignments have gone through. Does that help?
If he assigned me the rights to the house, I could come in, clean it up, and lease it out next week.
No, not correctly. You actually have to be the administrator of the estate. So you still have to go through the whole probate process. So I work with the investors that have been assigned these rights, and then when we file the case, about 6 to 7 weeks is what it takes to be the administrator. So that house still needs to sit there. Bills are accruing. It just all kind of sits there until you take it over.
Go ahead.
Now, I know you said something about creditors having 4 months to come after someone. Does that mean, like, you know, a lot of Americans, they have a whole bunch of credit card debt, so if grandma passes away or she knows she's going to pass away and goes berserk?
It generally doesn't happen. A lot of these Oh, yes. Of course. So her question is, what happens when grandma has a lot of credit card debt? She has $100,000 of credit card debt sitting there. What happens? Generally, I've been doing this for a long time, and a lot of credit cards, they don't even want to submit a proof of claim. It is easy for them to do so, but most of the times they do not. Big credit card debts, if you're looking at $25,000, $30,000 of debt, sometimes that happens when they do submit a claim. So that's always a possibility in any of these. But the point is that when you buy it as an investor, it's supposed to be a better deal anyways.
So the credit card company would see this as it's too difficult for them to hire counsel to litigate this, to whatever it is, whatever the case is.
Yeah.
It's easier just to write off the $12,000.
And I'm not sure exactly on their end what happens, but I do know that I have a lot of decedents that have debt because I've pulled their credit being a bankruptcy attorney, and I've seen so much debt and not one person has submitted a claim.
And that's a real powerful tool for all of you out there, because I guarantee you, when you speak to an heir and you ask, is there debts, like the idea that you understand they're not going to be collected, that can be a real benefit when you're negotiating with them on the price of the property. Because if I find out there's $186,000 worth of credit card debt, you better believe they're going to give me a discount of at least $186,000. And then if I'm working with the proper attorney, and that was, the very first part of your question, you said if I go to him and I do this and I put this together, I heard her say that she has very specific verbiage in her agreements that take care of the questions that the attorney have. And if you guys, all of you that are out there right now, hear me say one thing, I know very little about what it is she's talking about right now. I know enough, but I know very little of the specifics. What makes me powerful is that I call her and I let her take care of these things, because I can tell all of you right now, none of you should be doing this yourself. You should be hiring the right person to do the job. It's going to cost me, $15,000, $20,000 to have proper representation. But what happens is at the end of the deal, my deal doesn't get thrown out of court. So
Some of their agreements, but here's the thing, there's county specific. They're just very generalized, and when I make my agreements, as he loves, they're very detailed. I like everything in there. I like the judge to know exactly what's happening. I want them to know what is going on with the property. There is no foul play. There is no fraud. We're not trying to deceive the beneficiary. I still keep every client, they are always informed of what's happening. Even if they've assigned the rights, I will still keep them like, this is what's happening. This is the next step. This is what we're going through. So that everyone feels more comfortable as to like, okay, well, no, all of a sudden we just didn't hear from them and the house is gone.
And at the end of the deal, when a judge sees that there are paths and then they just dead end, and that me as the investor, her as an attorney, have taken these laymen, these people that don't know all the rules, if you've taken them, through a made up story or something like that, well, you're going to get killed. They're going to shut you down. And I just to answer the question about a NOLO press or something like that, I've owned a lot of those books, but what I'm telling you is I don't know what I'm doing. Okay, so I've read them all. I've read most of them, and I just don't. The specifics. It's just like anything else. If I told you we're going to win the Indy 500, well, I can drive. I can drive really fast, actually, but I'm not ready to win the Indy 500. You know what I'm saying? So anyway, So, the question that we have here is, what things are needed to best ensure successful probates from an investor standpoint? So I know we've kind of been talking about this right now, but if you could expand on that, that'd be nice. So I've just like I said, I found a house, or grandma's passed. I've got this deal going. One of these folks are going to be the buyers of the property. What are the kind of things that they should be? I'll give Mary some credit. So I'm involved in a deal right now with Mary and her husband, and Mary had a person that she knew, and she had some questions for me, and I gave her the advice of go and find everyone in the family you could possibly find, and then all I did, and Mary was able to determine, oh, this looks like the heir, but I just handed it to Mona, and Mona. Did it take 24 hours for us to have this all put together? I mean, it seemed like it went a lot faster than that. But anyway, please, that's what I'm talking about.
I am very open with my clients, so I explained this client exactly what's going to happen. She's from out of state, so we put everything together for her. I told her what's going to happen in probate. I could just hear her mind turning, and she said, "For how long? What do I need to do? I don't want to do any of this. Like, I understand I'm the heir, but this is," and she's like, "Can you give me like an hour to think about it? I'll call you back." She called me back with a lot of questions, and I told her, listen, like, I have an investor, this is what we do. Like, we could assign the interest, your whole heir, like to this estate, to somebody else, and he will take care of everything. She said, so I was reading I have to do last tax returns. I'm like, no, he takes care of all that. So lucky for me, I have a brothers-in-law and everybody that is an accountant. So we have a whole team that could take over all of that and figure it out and get it done. For her, she was in Ohio going, I can't do this. I don't want to do this. Where do I sign?
And from an investor's point of view, I'm just telling you guys right now, you should be out there looking for probate properties. These are people, and a lot of them. So please, all you real estate agents, plug your ears, because I'm not going to talk bad about real estate agents. What I'm going to say though is that a lot of them think they have this idea, or they read a NOLO. By the way, when I read all my NOLOs, I was a real estate agent. Okay, just trying to understand what is it I'm getting involved in. Okay, but as an investor, now I have income. Now I have something riding on this. Now I actually have revenue.
Two different things. There's a thing called full authority and limited authority. So whoever was the administrator of that estate depends on if they have limited authority. Limited means you have to go into court and actually do the whole sale within the court and have the judge approve it. If it was full authority, none of that matters. But there is a thing now that is an appraisal, and it's called today's appraisal. So you actually have it's called a probate referee. I don't know why they call it a referee, but they actually go and appraise the property again as of today, and then use that number to sell it. So it won't be a big gap, especially with the house prices being so high as they are now, that there's no way someone passes in 20 years that it's going to be not a good deal for the heir. So it's always, right now, it's the best deal. So we're not seeing a lot of capital losses in any of the probates. They're all just gains, and the court's okay with that.
The assignment is really what we're talking about. And guys, I brought her in to talk about probates, but really what I really want to share with you guys is the concept of an assignment. And I don't know if you know exactly what we're talking about. I see a couple heads shaking. No. So I'd like you to spend enough time to where they really understand, well, what it is we're talking about. So grandma's house, or my mom's house, she's passed. It's in probate. I got a million things going on. I don't want to mess with it. Her house is in Connecticut, and I live on the West Coast, and you have an investor for me. Tell me about this assignment.
Okay, so what happens is that if Jim has a grandma and he doesn't want to deal with the house, and we contact each other, I tell him this is how probate's going to work. There is fees, about $2,000 of probate fees. A lot of clients are having hard times with that. I know there's court waivers of fees and everything, but what happens is that these heirs are not even able to want to go in through a probate court. So when we talk about assignments, is that we are having an investor, Evan, come and give money. Basically, we talk about an assignment together between Jim and Evan, and they got
because I'm the heir.
Yes, he's the heir.
And so I'm assigning my rights to Evan.
And then I am representing Evan. I'm still in contact with Jim throughout the whole process. He will know what is happening in court the whole time. So he is assigning. Now, assignments, they have to be notarized. It is a specific document. That's what I'm talking about. The judges want specific wording on there.
And this is a document that you made custom for my situation.
Yes, and it's very detailed. It tells you exactly what's happening. Now, there's two different assignments. One between Jim and Evan that we keep private, and one that's specific for the court. The court one's a little bit more general, but the one that's just between personal between both of them to realize when the money's coming, what's happening, it all is very specific, exactly. Bank accounts, I'm very particular about what needs to be in there to make all the parties feel comfortable.
So on the assignment that she did for me, my wire instructions were on that document, so I knew where I had to send. So my agreement with the heir was that as soon as she signed the document, I would send her $30,000 and 2 airplane tickets and a hotel room, because she wanted to come out because she didn't. She's
She's
had
never been on a
pictures.
flight before.
Yeah, exactly.
She was very scared at the airport. I got several calls.
Yeah. So did you hear that? She got several calls. They didn't call me. It's worth the money. It's worth the money. Okay? I didn't have to
I'm
deal.
going to charge him extra.
Oh, there you go. There you go. Okay, so now you've come up with this wonderful custom assignment agreement, and we personally did a phone call we did a 3-way with Mona and the heir. And actually, she had who was that with her?
I believe it was her aunt, because again, these heirs, they're worried. They're worried we're not doing the right thing. They're worried this is a scam. They're worried this is fraud. So they always want like family members on the phone call, and this is why I like to put the investor on the phone call with them. This is not like a arm's length transaction. It is together. Everyone needs to know each other.
Yeah.
If they have questions, I want to be very open so they're more comfortable.
I loved it. I don't know what they said about the call that we had, but I took a minute to, first of all, say I'm sorry for your loss and try to develop. I mean, I have zero empathy. I'm the worst, okay? But I tried to at least let them know that, yeah, this is like, I'm not just here for the money, like I wanted to at least let her know that I'm sorry for the situation, and I'm here to help her do whatever it is, she needs to have done, so.
And it was fine, and we got off the phone call, and I called the heir back, and she said right away, okay, can you book my tickets? Where do I sign? So she was like, I don't want to deal with this. This is the best thing for this route.
And let me just tell you guys right now, this whole thing, I think you called me on a Friday, and I sent the money on Monday. Wow. That's how and this is a 1,900 square foot house in Mira Loma on a 0.7 of an acre that we're into for under $500,000. So it's a very, very nice deal. Gary, you had a question.
How do you determine, when you're in that situation, how do you determine what's a fair offer to that person without, obviously you're in a position, but what's a fair
Start low.
Yeah, but you have someone that's, I don't know, make it up in Ohio and it's 1,500 square foot house, they're like, I'll take $150,000 for it.
I mean, I would have paid more. I would have probably paid more if I had to. But in the end, you know as well as I do, we all think we're rich when we first sign up the deal, and at the end of it, 20,000 goes here, 18,000 goes here, 38,000 goes here. Oh,